And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
A legal war over the AR-15 has quietly begun. A silent battle is being fought across America, not in headlines or primetime debates, but in courtrooms and city councils. At the heart of this fight, the AR-15, the most popular rifle in the country, owned by millions, used for sport, home defense, and protected under the Second Amendment. Yet right now, in a small city ordinance and a little-known court case, a trap is being set, one that could put millions of legal gun owners at risk. And this time, it isn't coming from Washington. It's coming from local governments working below the radar, hoping no one notices until it's too late. The stakes? If this trend continues, your AR-15 or any semi-automatic rifle could be declared illegal in your city or state, even if the Supreme Court never bans it. This is not about fear. This is about legal facts. And if you value your rights, you need to hear what's happening right now. The quiet battle no one saw coming. While most eyes were watching Washington and the Supreme Court for big rulings, a city council in St. Paul, Minnesota, made a move that could ripple nationwide. They passed an ordinance requiring registration and extreme restrictions on AR-15-style rifles and similar semi-automatic weapons. This wasn't just about banning future sales. This ordinance is trying to force current owners into a legal corner. Comply with the registration or become a criminal. No public vote, no statewide debate, just a city-level decision. Gun owners had little notice and even less power to stop it. The language used mirrors parts of the national ban proposals. Violation of this ordinance could result in heavy fines or worse. This was the first clear shot in a legal war that's spreading. And here's the catch. It was designed to provoke a lawsuit. That lawsuit is now here, and it may be headed to the Supreme Court. The fear-based legal trap. The case tied to this controversy is Grant v. Rowella, a straightforward-sounding name, but a deeply dangerous legal weapon. It involves a city defending its ordinance by using fear-based language, claiming that the presence of AR-15s increases risk, makes the public less safe, and justifies extra regulation. This isn't new, but the way they're doing it is. The city argues that AR-15s are uniquely dangerous. They claim public safety overrides individual firearm ownership. They want the courts to accept subjective fear as a legal justification. If accepted, this would set a precedent for other cities. And if a court upholds this reasoning, any locality could claim that banning a firearm is justified based on community fear, not actual misuse. Think about what that means. Your city could ban your firearms based on emotion, not evidence. And once a court signs off, it spreads like wildfire. This is the legal trap being laid, and it's already catching momentum. AR-15, popular, legal, and under attack. Despite media headlines, the AR-15 is not a fringe weapon. It is the most commonly owned rifle in the country. Millions of Americans use it responsibly. The Supreme Court has already acknowledged that commonly used firearms receive constitutional protection. So why is it under attack? The term assault weapon has been redefined in legislation. Local governments claim military-style appearance justifies regulation. Courts have been split on how to interpret dangerous and unusual standards. Activists use tragic events to pressure judges and counsels emotionally. The truth is, the AR-15 has become a symbol, and that symbol is now a target. Not for what it does, but for what opponents claim it represents. The law should not bend to symbolism, but if we let it, we open the door to bans based on looks, names, and media narrative rather than function or fact. What the Supreme Court has already said. In the 2022 Bruin decision, the Supreme Court made something clear. Gun laws must be consistent with the historical tradition of firearm regulation in America, not based on modern fear or political preference. That ruling changed everything. It set a new test. Is the regulation rooted in historical precedent? It removed the old balancing test that weighed public safety against rights. It forced lower courts to reevaluate bans and restrictions. It specifically mentioned that commonly used weapons are protected. St. Paul's Ordinance and others like it struggled to pass that test. There is no historical precedent for banning a rifle because of how it looks or because people are afraid of it. This is why Grant versus Rowella matters. If it reaches the Supreme Court, it will be judged through this Bruin framework. And the outcome could end or encourage local AR-15 bans nationwide. What cities are quietly doing next? St. Paul is not the only one. Cities across the country are now watching what happens. Some are drafting similar laws, others are waiting for legal cover, and many are consulting the same legal playbook: use emotion, redefine terms, and push local ordinances to the edge of constitutionality. This trend is growing. Local bans offer a testing ground, free from national scrutiny. Activists are encouraging cities to take action while Congress is gridlocked. Courts have inconsistently ruled, creating a patchwork of risk. Many gun owners don't even realize their rights have changed until it's too late. The strategy is clear: change the law from the bottom up, one ordinance at a time. If this is not stopped at the judicial level, it will spread city by city until the Second Amendment means something different in every zip code. The emotional cost of political battles. To many Americans, the AR-15 is more than a rifle. It represents liberty. It's a tool of protection, of sport, of responsibility. But to opponents, it has become a symbol of violence and political division. And that clash of perspectives is being exploited for legal and political gains. The result? Honest citizens are now caught in the middle. When lawmakers argue over optics instead of facts, the real cost is borne by people who have never committed a crime, but still wake up each morning with fewer rights than the day before. Key consequences for gun owners include widespread fear of legal uncertainty, increased prosecutions for previously legal behavior, local laws override long-standing traditions, political symbolism replacing objective reasoning. The erosion of trust doesn't happen in one sweep. It builds slowly with vague legal definitions, shifting rules, and political narratives replacing constitutional clarity. The court's silence so far. Here's where it gets even more serious. The Supreme Court has not yet directly answered the question: can the government ban a firearm that's widely used for lawful purposes? What's happening in the courts now? The Ninth Circuit supported a California-style AR-15 ban. The Fifth Circuit blocked similar laws based on the Bruin standard. Lower courts are issuing contradictory rulings. Temporary injunctions confuse what's allowed from state to state. Now, in Grant versus Raola, the justices are being asked to speak clearly. This isn't just about one city. If they take the case, their decision could affect millions across all 50 states. What happens if they say nothing? Every day the Supreme Court stays silent, new laws pop up in different states, each with its own language, restrictions, and penalties. Without clarity, gun owners face. Legal rifles are turning into banned weapons overnight. Confusion about transport laws across state lines. Risk of felony charges due to minor legal missteps. Constant fear of sudden enforcement crackdowns. Without a unifying ruling, the legal system becomes a patchwork where the same action can be lawful in one zip code and criminal in the next. All lies on the Supreme Court. The Supreme Court has been slow to act, but pressure is rising. Conflicting rulings from the lower courts have created chaos across the country. States are enforcing laws that contradict not only each other, but recent Supreme Court decisions like Bruin and Heller. What's at stake now? Whether commonly owned still protects civilian firearms. Whether subjective definitions of dangerous or unusual can justify bans. Whether cities can bypass constitutional rights by declaring public safety emergencies. Justice Amy Coney Barrett may be the deciding voice. She has supported strong originalist interpretations of the Constitution, but has also leaned toward cautious rulings. Chief Justice Roberts, often seeking compromise, may try to narrow the ruling's scope, but this case demands clarity. Vague decisions will only prolong the confusion and give anti-Second Amendment legislators more room to push limits. This isn't just another legal battle, it's the one that could decide the future of modern firearm ownership in America. This isn't just about rifles. The fight over the AR-15 is not just about one firearm. It's about a legal boundary. If the courts allow bans on rifles that are commonly owned, used for lawful purposes, and protected by precedent, then the door is wide open for broader restrictions. Here's what could follow. Magazine capacity bans that criminalize standard 15 or 30-round magazines. New classifications are making semi-automatic pistols assault weapons. Restrictions on popular attachments like red dot sights or flashlights. Legal reinterpretations of ammo types like hollow points or full metal jackets. This is the strategy to chip away at rights by redefining terms. Today it's about features, tomorrow it's about intent, and soon it could be about mere possession. Once the definition of what's legal becomes flexible, no firearm is truly safe from legislative attack. This is why Second Amendment attorneys are watching Grant versus Roella so closely. It may be about St. Paul today, but the implications are national. The moment that could reshape everything. We are standing on a constitutional cliff. One ruling from the Supreme Court could decide whether you get to keep the firearm you've owned for a decade or become a criminal for it overnight. These aren't theoretical threats. They're laws already on the books, in cities and states that want to set a precedent. The fight isn't just in courtrooms, it's in your neighborhood, your state house, and your ballot box. Because once one law is allowed to stand, others will follow faster than you think. So, what can you do? Stay informed, because ignorance of the law is not a defense, and bring you what actually matters. And above all, never assume your rights are safe just because they exist today. The next chapter of the Second Amendment is being written right now, and if you're not paying attention, it might be written without you.